Greetings, everyone. My name is Sheila S.Q. Bronson. Today I'm a juror, and I've been given the charge of weighing the evidence in a case. The plaintiff being Gina Myers, and the defendant being Ashford Hospital, which is represented by Darcel G. The following information of the case is as follows. The patient, Gina Myers, who is also an employee of Ashford Hospital, was admitted for surgery due to tonsillitis. An email was sent out to all employees of an operating room schedule of her upcoming surgery. The information in the email included, but is not limited to, her social security number, her date of birth, her age, her residency, her insurance and payment information, former surgeries, former and current medications, past medical conditions, primary healthcare physician, current psychiatrist, and other healthcare professionals that she's seen within the past year. HIPAA, which is the Health Insurance Portability and Accountability Act, protects individual privacy rights against willful or negligent violations, which causes both emotional and financial harm. This law regulates privacy and security of health information. A covered entity or business associate may only use or disclose the information as required or permitted by the privacy rule or as authorized by the individual. Rufert, 2016. A case came before the Connecticut Supreme Court. Emily Bryan was in a relationship with Ando Mendoza from May to September 2004. During this time, Emily became pregnant. Long story short, the relationship ended before Emily gave birth, and Mendoza filed for paternity. Emily instructed the Avery Center for Obstetrics and Gynecology not to release any of her medical information. They were, however, subpoenaed and then informed Emily of the subpoena and sent a copy of her medical records without her permission to the courts. Emily sued Avery Center for Obstetrics and Gynecology, alleging that they were negligent in failing to use the proper and reasonable care to protect her medical information. Further, this negligent conduct caused her emotional distress. This is a textbook example of a HIPAA violation. While tonsillitis for a patient having surgery should be kept confidential along with other personal information, that is not the case here. Tonsillitis is contagious and can be transmitted by contact with other infectious persons, such as a cough or sneeze, and it releases little droplets, and you get infected. Or in a work setting where you touch phones, keyboards, cups, things like that, and you can also be infected. This makes this a work-related illness. The employees are required by OSHA to maintain all illnesses and injuries, and they keep a record of this. The Occupation Safety and Health Act of 1970 is a law that covers more than 6.5 million employers and 100 million working men and women, according to OSHA 1998. Therefore, this falls under the terms of occupational medical record, occupational health record, and employee health record, which are often used interchangeably. Okay, these records can be part of the employee's health record as well as the patient record. Occupational health services provide that employer to employee are not covered under the HIPAA Okay, so according to the Privacy Security Occupation Health Records 2013, the Department of Health and Human Services repeatedly stated that the privacy rule does not apply to employers, nor does it apply to employment functions of covered entities. This means that because this is a work-related illness, and then it doesn't fall under the Privacy Act, and that all entities that are covered under OSHA will have right and access to those records and that information. Therefore, a senior administrator will have right to those records. So in that case, I am going in favor with the defendant and finding that they did nothing wrong and that they did not breach any privacy rules. Thank you.